And the enactment of our new, latest, not so new actually, Arbitration Act in 2005, okay, where we adopted the arbitral model law, okay, mark a transition to a modern regime. For the first time, we kind of got away from the English provisions, but rather we focus on making our law in order, or maybe we can say more aligned to the New York Convention 1958. Yeah. So under the Arbitration Act 2005, we have sections 38 and 39, where I will go through in detail later on, where prescribe laws on how international arbitral awards can be enforced and recognized in Malaysia. Okay. And in the 2011 and 2018, we also have certain amendments to make sure that our law to enforce international awards are more closely related to or closely aligned to the arbitral model law and also the New York Convention 1958. What do we have on Section 38? Okay, here are our current legislation, Arbitration Act 2005, okay, which made it mandatory for award made in Malaysia or made in foreign state. So this Arbitration Act covers both domestic arbitration and also international arbitration. Yeah. So Section 38(1) requires awards made in either in Malaysia or in foreign state to be recognized as a binding and enforced as judgment in Malaysia. Okay. So even though Vegitya 1958 is still there in Malaysia, is still enforced in Malaysia, but awards, yeah, made in foreign state can directly be recognized as binding as judgment in Malaysia through the Arbitration Act 2005. What about the application procedure? So under Section 38, Section 2, the applicant must apply in writing to the High Court, okay, by just following the requirements set up. Actually, this is set up under Article 4 of New York Convention 1958, which the applicant just need to supply these two things. The first one, the authenticated original award or duly certified copy of the award, yeah. And second, the original or the certified copy of the arbitration agreement. So there are just two requirements. First, arbitration agreement. Second, the original award. And then prima facie, the Malaysian High Court would enforce and recognize the award made by the either foreign state. Okay. However, okay, in Malaysia, yeah, when acceding to the New York Convention 1958, okay, we actually had two reservations. Okay, so we will not enforce directly awards made by all states in the world, but rather the first requirement is reciprocity requirement, i.e., okay, the enforcement is limited to only awards made by another contracting states of New York Convention 1958. So another 169 states of New York Convention, we will enforce those awards. Yeah. And the second reservation that we made was we only recognize disputes that are considered commercial under the Malaysian law. Yeah. Only commercial matters. I believe this is a little bit similar to the position in Indonesia. Maybe later on, Dr. Maria can further elaborate on this. Yeah. So the awards are enforced procedurally as judgment without re-examination of the merits of the award. So there is no need for executor, there is no need for the parties, okay, that sought to enforce the award to first apply, and the court will need not to check whether the award is sufficient, whether the award is eligible or not. As long as the two requirements are satisfied, i.e. the arbitration agreements and also the duly certified or original copy of the award has been presented, okay, to the court, then the court will then enforce those awards. And recent judicial approach, because we are a common law country, okay, our main law would be the Act, i.e. the legislation, and also the case law. So the latest law cases, okay, gave us procedural right. So as long as the party is able to prove those two things, the enforcement is granted as of right, unless they apply to refuse the enforcement of the award under Section 39. Section 39. So Section 39 of the Arbitration Act 2005 stipulates limited ground of refusal where the High Court may refuse to enforce the award. So 38 mentioned that, okay, as long as you fulfill the two requirements, then the award may be enforced. But the other party, the party that against the enforcement of the award, can also at the same time apply to challenge or to refuse the recognition or enforcement of the award following the 7 requirements. Yeah, we have 7 sections. The first 5 is under Section 59, Section 1, which is actually in pari materia or in line with Article 5, Section 1 of the New York Convention 1958. The first one is invalid arbitration agreement. Yeah, so the parties can apply to refuse enforcement by challenging that, okay, the arbitration agreement presented by the other party is not valid. Yeah. Second one, they can also say that there is no proper notice to them and so make them unable to present their case during the proceeding at the scene of arbitration. Yeah. And the third one, they can also mention that the award exceeds the scope of the arbitration agreement agreed by the both parties. Because arbitration works very closely to the principle or the theory of party autonomy, where the parties must consent via the arbitration agreement. So if the award awarded by the seat of arbitration exceeded the scope of arbitration, that would be one of the valid grounds to refuse the enforcement of the award as well. Fourth, irregular composition of the tribunal or the procedure, i.e. the tribunal, i.e. the arbitral tribunal, must follow the procedure set up, okay, under the arbitration agreement. And fifth, the award not yet binding or has been set aside or suspended by the seat of arbitration. So basically, the Malaysian court, okay, will not enforce award that has been set aside by its original date, where the award was made. The other 2 grounds would be under Section 59, Section 2, which is also in pari materia with Article 5, Section 2 of the New York Convention 1958. The first one relating to the non-arbitrability of the subject matter, and second, if it is contrary to the public policy of Malaysia. Yeah? And the Malaysian court will try to interpret the public policy narrowly, i.e. pertaining to public policy that is recognized under international law. Also, Section 3 of Section 39 mentioned that if only part of that award is unenforceable, the court will still enforce the rest. This reflects the severability of principle under the New York Convention 1958. So, theoretically, under our Act, we have these 2 sections, only 2 sections, but very important sections that actually guide us relating to the enforcement and recognition of the foreign awards in Malaysia. Or I made it into this table here, okay. So when the party, okay, from another state, okay, would like to enforce an award made in another contracting state in Malaysia, what they need to do, and Section 38, they need to file at the High Court under Order 59 of the Rules of Court 2012, submit award and the agreement. Yeah, it must be, okay, an award made by another contracting state and must be about commercial matter, because that was 2 of our reservation. But if the parties manage to prove all the requirements, then the court will prima facie review and there will be automatic recognition of the award. But the parties, the other parties, okay, can object, can make application to refuse or challenge the award under section 59, okay, under the 7 grounds that I have mentioned earlier. Okay, and then the court will decide whether to enforce the award or whether to refuse enforcement of the award. That would be the procedure in Malaysia. Okay. Looking at the judicial attitude or the law cases in Malaysia, we can say that the Malaysian courts adopt a narrow interpretation and of refusal grounds of Section 39. Okay, i.e. adopting the principle of pro-enforcement bias, okay, to allow enforcement of foreign awards as much as possible, unless one or more of the 7 grounds could be proved by the other conflicting parties. Among the important judicial precedents is the case of Almira and Syaifuddin, yeah, where the court discouraged invalidation on procedural technicalities, yeah, and the case of aggravated LL.M, where the court stressed on the strict compliance of formalities. So as long as the grounds of Section 59 is fulfilled, the court reiterated that the court must enforce and recognize the award unless one of the grounds under Section 59 can be proved. In the case of Jacket and Taraf Consulting in Den Berhad and Siemens Industry Software, the court also affirmed the enforcement as of right upon fulfillment of procedural requisites. Because to fulfill our obligation under the New York Convention, yeah, it is very important for the Malaysian courts, okay, to treat the requirements under Article 4 of New York Convention under 58, yeah, i.e. to try to enforce the award as much as possible unless it goes against or the public policy of Malaysia or contrary to our public policy, and also fulfill one of the 7 grounds that I have mentioned earlier. I would also like to draw some attention, to the recent cases, the last 5 years cases relating to the international awards in Malaysia. For example, the first case of ADVAC Scandinavia and Muhibat Engineering. Okay, this is a Qatar-seated arbitral award. Okay, where the parties sought to enforce it in Malaysia. Yeah, the key judgment is that this is relating to the public policy. So the court reiterated that, okay, the public policy objection must be properly raised via application under Section 59 and not merely by affidavit. And here, the enforcement of the award was allowed because the defendant improperly objected without making a formal Section 59 application. Okay, this reflected the pro-enforcement bias, the positive judicial adherence to the New York Convention by the Malaysian court. So the case reinforced the 2-stage process under Malaysian law, i.e. formal registration of the award on Section 38 and the challenge on Section 59. The courts here discourage abuse of process and support strict procedural compliance to uphold enforcement of the award. Another case would be the case of Hindustan Oil Exploration Co. Limited and Hardy Exploration. This is relating to the alleged misapplication of limitation law, and here the court ruled that limitation issues are procedural and not substantive, whereby the court, okay, must not review merits of arbitral awards, but rather respecting the finality of arbitration decision. So decision of the arbitration must be respected because it must be final. Okay, if the parties would like to set aside the award, the parties need to set aside under Section 37 of the Arbitration Act 2005, i.e. to challenge it to set aside of the award at its original seat, where the award was made. So here, the case reaffirmed the Malaysia's non-interventionist approach that is in line with the pro-enforcement bias of the New York Convention. The other case is the case of Mesna Sedang Berhad in Sabah Nilam. Yeah? This is related to the jurisdiction and enforcement of domestic awards, but still important. Okay, where the court highlighted that the seat of arbitration will determine, okay, the exclusive supervisory jurisdiction of the court. So if the parties would like to set aside the award 100%, then it needs to apply to the seat of arbitration. So, for example, if the award is made in Indonesia or maybe made in Singapore, okay, the parties that would like to set aside the award in its entirety must then go to the seat of arbitration to set aside at the court where the award was made. The seat, okay, the court where the seat was would be the supervisory jurisdiction for the arbitration award. So the enforcement court can only refuse the enforcement but could not set aside in its entirety. I have not yet get the opportunity to listen to the other speakers' comparative analysis, but what I can suggest, or I can from my limited knowledge of how Indonesian Malaysians are. In Malaysia, we are the attitude in Malaysia, the judicial attitude is more into pro-enforcement with minimal intervention. Yeah, because our law mentioned automatic recognition upon issuance of awards and arbitration agreement, where then the parties can challenge through Section 59. Okay. So what I would like to highlight here, Malaysia has transitioned from colonial legal transplant, okay, before pre-1985, into adopting international best practice model by adopting the arbitral model law, but we also made it or tweak it a little bit to make sure it aligns to our own law, okay, to enhance our investor confidence and also to make sure that Malaysia could be one of the choice for arbitration seat. Yeah, and we hope that with Indonesia's reform commitment and also our own transformation, both countries can reflect ASEAN's evolving arbitration landscape, okay, which highlights the need for consistent application to foster certainty and predictability in cross-border commerce. Because in international commercial arbitration, what the parties sought is actually certainty and predictability. They want to know if they do arbitration here or there, whether the awards could be enforced, whether the award is recognized in these countries or not. So I believe those are the conclusions for today. We hope that the students and also fellow colleagues from Universitas Sriwijaya, okay, can may perhaps learn something, even though small, of what we do have in Malaysia, what we are doing right now. And then I'm looking forward to listen to presentation from Dr. From Universitas Sriwijaya, our other speaker, relating to what actually the position in Indonesia relating to the recognition and enforcement of international awards. I think that's all from me, Ms. Moderator.
Okay, thank you so much, ma'am. Thank you very much, ma'am, for giving us such an informative and interesting presentation.
I can't hear Ms. Moderator.
Oh, sorry. You can hear me?
I can't hear.
Excuse me, ma'am. Do you hear me?
I still can't hear. I'm so sorry. I'll stop sharing now. If that will be helpful.
Okay, how about now, ma'am? Can you hear me well? Okay, ma'am. Thank you. Can you hear me now?
Yes.
Okay. Okay, thank you. Okay, thank you so much. Okay, thank you very much, ma'am, for giving us such an informative and interesting presentation. So, ladies and gentlemen, for the question and answer will be held in the next session. Now, let's move on to our next speakers, Mrs. Dr. Maria Utama, S.H.L.M. Okay, good morning, ma'am. How are you? Okay. Okay, so the next presentation will be shared by Mrs. Dr. Maria Utama, S.H.L.M. She is an associate professor in Faculty of Law, Sriwijaya University. She obtained her bachelor degree in international law from Universitas Sriwijaya and continued her master degree in Erasmus University of Rotterdam, Netherlands in 2004 and graduated 10 months later. Then graduated her doctoral study in Pajajaran University with GPA 4.0 on August 2020. Now allow me to welcome the speakers, Mrs. Dr. Maria Utama, S.H.L.M. to deliver her presentation. Ma'am, time is yours.
Thank you so much, Miss Moderator, the beautiful one, Miss Riza. And hello, Dr. Ilyana. It's nice to see your presentation, and then it is very interesting. And then seems that I learned much from your presentation there. So, baik, I would like to continue. If Dr. Liliana discussing about the recognition and enforcement of the Arbitral Award in Malaysia, then I will discussing also in Indonesia. Continue. Actually, as I mentioned just now, that nowadays more and more companies prefer to have their arbitration clause within their agreement rather than to let the court take over any possible dispute in the future. So I think this is happen in every country, that they are mostly prefer choosing arbitration than any other mechanism such a court to settle their commercial dispute. So this is indeed highly reasonable, considering that arbitration is seen by many as an alternative dispute settlement that has more advantages compared with other dispute settlement media. So I'll discussing this to the students, because some of you also still bachelor's degree students. So I think I will repeat also what is the advantages of arbitration. The first, that it is decided by the expert. Yeah, expert for about if in Bani it is for about 15 years expert. Yeah, and then it is amicable mechanism, so the party can decide the discussing first about their problems, and then after that, if they are agree, so the institution can make the award based, yeah. So it is amicable mechanism, and then it is fast settlement for about 180 days based on the Article 48 Indonesian Law number 13 of 1999. And then I said to you just now, it is final and binding, recognized by Dr. Ilyana said just that currently it is about 170. I mentioned 166 based on 2021 registered, yeah, by the New York Convention. And then you can see, continue, you can see the dispute sector. Actually, there are many institutions that has a wide range of the dispute sectors, such as maritime, franchise, yeah, and then also energy, life science, construction, commercial, like what Ms. Riza said just now. What kind of problem or dispute actually that settled by the arbitration? Currently, if Indonesia especially, the constructions dominate the yes, construction and mining dominate the dispute that must be settled by the arbitration. So others ask about the international trade, and then also about the corporate, and then any others cases. Yeah. So I take this from dispute register website, and then continue. Why recognition and enforcement is very important? Actually, I say that it is an old issue and has been discussed for a long time ago. Start from 1923. It is a protocol on arbitration clause. Start from League of Nations already discussing about how to recognize and enforce the arbitration actually. And then 1927, it is the convention of the execution of the foreign arbitral award. But the popular one is 1958 that Dr. Iliana also discussing just now about the convention on the recognition and enforcement of foreign arbitral awards that discussing by United Nations. And then the last is 1988, chapter 8 about the United Nations Convention on the UNSRI model law. Yeah. So why discussing about the recognition and enforcement is very important? Because whenever the arbitral awards is challenged, means that we can say that it is the standard of effectiveness of the arbitration process. It's become negative issues. So whenever one's arbitral award is challenged, it will be lead to the negative issues, means that maybe the arbitrator is not competent or the institution is not competent. So whenever I forget the name of the scholars, they said that arbitrators is a nobile officium. Maybe currently all of you do not think is that whenever you are graduated from your current study, you will become the judge or the prosecutor or from the lawyer. But arbitration currently is also what we call is a noble officium. Yeah, noble officium. Arbitral awards, from Huala Adob says, he is the vice leader from Bani, said that arbitral award is cum laude riders. Yeah, so means that paper that made only for the student who has cum laude, means that it's not easy to making the arbitral award that can be easily challenged by the parties. Continue, Muji. You can see this is the chart of the case. Yeah, from the chart of the case, I try to copy from many institutions like London Maritime or Arbitration Association, and then ICDR, and then ICC, and then SIEDAC from China, SIEC from Singapore, and then also Hong Kong, and then DIT from Germany, and then other institution. Actually, arbitration indeed very popular to solve many dispute regarding commercial things. Yeah, or we can say that arbitrability. Next. And then what about the arbitral award? It is also final and binding based on Article 16 Indonesia Law Number 13 of 1991, and then the party and voluntarily carried out the arbitrator's decision. Actually, whenever the party already choose the arbitration without registering the arbitral award to the court, the parties must be voluntarily implemented the decision, of the arbitral award. But if the parties reject the arbitral award, it may be enforced by legal proceeding. And then why this is happen? Many things happen why the parties try to challenge the arbitral awards. Number one, maybe they are not in a good faith. Yeah, they try to postpone what said by the arbitral award is said mostly by the losing parties. Yeah, the losing parties challenge the arbitral awards. And then maybe it can be unsatisfied to the arbitrator's decision. Yeah, of course. Yeah, if they are unsatisfied, then they are challenge the arbitral award to the court. What about the arbitration in Indonesia? Bani says that they have the negative issues. Yeah, they have the negative issues, that there is a perception that Indonesia court is not cooperative with the foreign arbitral awards. Let us see later. I try to capture some of the decision that can accepting and refusal by the prime court. Yeah, the enforcement of the exequatur of foreign arbitral awards in the jurisdiction of Indonesia is considered as extremely difficult and time consuming. Yeah, I made some chart. Actually, this is based on the Perma number 1, but Alhamdulillah, yeah, the prime court and on 2023 already made a decision and then make regulation number 3 that stipulated many things that do not covered by the regulation number 13 of 1999. What about the procedure? Is it complicated? You will see later. Is it complicated or not complicated? And then regulation supported. What about the annulment of the award? Then continue about the relevant regulation. Beside law number 13 of 1999 on the arbitration and dispute resolution or arbitration law, we said, is it also presidential decree number 34 of 1981 that ratified the New York Convention, that is very popular as the ground of the parties that they must recognize and enforce the arbitration award. And then the New York Convention 1958 on the recognition and enforcement of the foreign arbitral award itself, we said New York Convention. And then the guideline of Supreme Court in National Award Meeting 27 and guidelines of Supreme Court in National Award Meeting 29. Yeah. And then I'll continue to the general procedure. The general procedure from register stage up to the real enforcement stage, yeah, the enforcement of foreign arbitral awards require court involvement and it shall meet the criteria as set out in Article 66 of the arbitration law. The first is the award was rendered by the arbitrator or arbitral tribunal in a country with which Indonesia has a bilateral or multilateral agreement concerning recognition and enforcement of foreign arbitral awards. We see just now that Malaysia also the participant of New York Convention 1988 means that if the decision or the arbitration award made in Malaysia or also in Indonesia, it can be enforced in both countries. And then the decision concern must be in commercial matters, and then it does not contravene Indonesian public policy. And then a stipulation of enforcement or exequatur to enforce the award has been issued by the Central Jakarta District Court. So for award where Republic of Indonesia was the party for the case, for instance, Extit award, the stipulation of enforcement must be issued by the Supreme Court to be further executed by the District Court. So there are two arbitrations award, means that national arbitration and then it is international arbitration. If national arbitration, it must be registered to the court where the arbitration is held. If it is international arbitration award or arbitral awards, means that it must be registered to Jakarta District Court. Yeah, so that is the difference between national and international arbitration general procedure. Continue. There are three stages actually for the simple things. The first is registration, and then after that enforcement, and then actual enforcement. I divide it into three stages. Continue, Pak Muji. Next, this one is the registration. So submitting the application of the registration with the supporting documents, and then delegation, or we say in Indonesia disposisi, from the chairman of the Central Jakarta District Court to the Civil Application Division, and then continue to the review application, and then registration of the database from the Central Jakarta District Court, and then deed of registration. So it's quite the same with Malaysia. Whenever it is registered to the court, means that the court do not see the problems, yeah, so only see the arbitral award itself. And then continue for the stage 2, the enforcement. After obtaining deed registration, a stipulation of exequatur from the chairman of the Central Jakarta District is required for the enforcement of the foreign arbitral award. The registration stage only means that the award is registered in database of Central Jakarta District Court. A specific application must be filed to the Central Jakarta District Court to obtain the stipulation. It is just administration procedure actually, yeah. The arbitration law does not provide a time limit for. Okay, it's okay. Continue with this stage. No. Back. Okay, stage 2. Continue. All right. So from the stage 2 just now, after continue, Pak Waji. Now continue. Okay. Check of the stage 2. So after submitting the application of exequatur, then it is delegation from the chairman of the Central Jakarta District Court to the Caesar Division. So it is, we said in Indonesia bagian sita. The court register appoint the court's bailiff, ya, bailiff itu jurusita, and then after that the court bailiff request relate document to civil application division. Now actually, if the parties are voluntarily would like to obey the arbitral awards, so this kind of complicated stage is not necessary, yeah, it's not necessary. So after the court bailiff request related document, then the civil application division provides the court bailiff with the related document, and the court bailiff draft the summary of the relevant arbitral award. The court bailiff submits the draft of the summary to the chairman of the Central Jakarta District Court, and then after that, the continue to the chairman of the Central Jakarta District Court, check and review the summary with the application of exequatur and the issuance of stipulation of exequatur or stipulation of non-exequatur. Yeah, it's quite long ways to go. Yeah, long ways to go. Continue the next slide. For the stage 3, the writ of the execution, or we say piat eksekusi, after obtaining the stipulation of the exequatur, the winning party may apply to the Central Jakarta District Court for a writ of execution under general rules of enforcement under Indonesia civil procedure. So we are using Indonesian civil procedure or hukum acara perdata in Indonesia. Then the application of the writ of execution shall be considered as the application of actual enforcement. And then the court may issue a writ execution if the losing party, after being duly summoned and so requested by the court, does not voluntarily comply with the award. If the location of the asset is outside the jurisdiction of Central Jakarta District Court, then the implementation will be delegated to the competent district court of the asset. Yeah, delegation procedure. For instance, it is registered to the Central District of Jakarta, but the asset is in Palembang. Then there will be delegation, yeah, from District Jakarta to the court in Palembang, yeah. And then fiat eksekusi is actually the actual enforcement process for all arbitral awards, both domestic and foreign. And also for Indonesia court judgment, for example, Indonesia Supreme Court, under general law on civil procedure, just now, the latter is a distinct process under different set of rule on civil procedure applying to the enforcement generally in Indonesia. Continue to the chart, Pak Muji. Okay, so this is chart of stage 3. The procedure of fiat execution is as follows. The issuance of stipulation of exequatur. After there is exequatur, so the issuance of stipulation of exequatur, and then submitting the application of the actual enforcement, drafting of unmanning exhortation letter is including its correction by the court bailiff, and then submission of draft of unmanning to the chairman of Central Jakarta District, issuance stipulation of unmanning, kemudian and then drafting narrative or relas of unmanah, ada unmanah to be delivered to the respondent of the rule enforcement, and then deliver to the relas and to the respondent of the rule enforcement, drafting the stipulation of actual enforcement, and then signing the issuance of stipulation of actual enforcement by the chairman of Central Jakarta. It is if the situation is in Central Jakarta, but if it is in another district area, then come to the next chart. It's quite long way to go. Continue. Yes, this one. Signing and issuance stipulation of enforcement by the chairman of the Central Jakarta District, and then continue code registration, blah 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 blah, and then after that, long way to go. Then the chairman execution district court delivers the report to the chairman of Central Jakarta District Court with the cover letter. You can read this one. So if it is international arbitration award, indeed it is a very very long time to comply the arbitral award. Okay, then we can continue. Nah, challenge of the arbitral award. So in Indonesia, also discussing about this and then stipulating about this, a party may seek to annul an arbitral award by filing an application with the relevant district court. Actually, whenever we are discussing about the principle that arbitral award is final and binding, actually there is no ground for challenge of arbitral award, but still the parties try to challenge. Therefore, Indonesia try to stipulate about this under Article 70 of the arbitration law, Article 24.4 of the section registration number 3 of 2023. Number 1 is the ground for the challenge is the letter or document submitted in the arbitration hearing after the award has been rendered are proven or declared to be fraudulent or false. Jadi memang ada kesalahan atau ada pemalsuan to the document. And then number 2, discovery of material document after the award has been rendered that was intentionally concealed by the opposing party, and then the award is rendered based on the fraud that was committed by one of the parties in the processing. Okay. So this is the ground of the challenge of the arbitral awards in Indonesia. Under the Article 71, the arbitration law, Article 24.1, Supreme Court Regulation number 3 of 2023, such application must be filled within 30 days, within 30 days of the delivery and registration of the award with the relevant district court. And then a district court judgment granting the annulment of an arbitral award may be appealed to the Supreme Court. On the contrary, if the district court rejected the application, the decision of district court cannot be appealed. So continue to the chart, the graphic. So due to the limited time for browsing, I found that this is the current status of the foreign arbitral awards from 2000 to September 2018. 18, yeah. This is, you see the green one, it is stipulation of the exequatur. So the party comply the arbitration award after the exequatur. And then the red one is stipulation of non-exequatur. And then number 42 is no information of exequatur. And then awaiting stipulation exequatur from the chairman of the Central Jakarta. And then internal state between civil division and seizure division. And then postpone of the exequatur relation with requested one cases, yeah, at 2018. It's quite a long time ago. Why I put it in here? The situation is not really different currently, yeah. Then continue. Nah, actually, there is a new development of arbitration in Indonesia under Supreme Court Regulation number 3 of 2023. Is it a new down? Not made down, yeah. It is a new down. It is a new hope, yeah. The Supreme Court recently announced domestic and international arbitration by enacting Supreme Court Regulation number 3, 2023 on the procedure of the appointment of the arbitrators by the court. Yeah, so the Supreme Court Regulation number 3 try to complete the regulation number 13 1999 that not stipulate not regulate, yeah, some of the cases of the arbitration in Indonesia. So this client alert with highly key features of the regulation detailing the change that will reshape Indonesia as the next emerging dispute resolution across the continent. And then it is under Supreme Court Regulation number 1, there is a definition of public order. It is deemed to be violated if an arbitral award evidently contradicts to the fundamental principle of the entire legal system and society in Indonesia. And in comparison, the regulation number 3 of 2023 define public order as everything that constitutes the very foundation essential for the functioning of the legal system, economic system, and social culture system in Indonesia, community and nation. I saw just now the presentation of Dr. Liliana. It is, we say also do not violate the commons, yeah, just commons, yeah, the basic principles in international. And then number 2, time management for the court is vital for focus under regulation. If just now the chart I made, there is no specific time. There is no specific time consuming. So under the court regulation number 3 of 2023, there is limited time. Continue, Pak Muji. Nah, so this is the new regulation mandate, yeah. It is 40 days deadline for the district court to appoint arbitrators upon receiving the request from either parties. You see that from one cases, sometimes the parties do not agree to the third arbitrators. So arbitrators can be 1, can be 3, can be 5 arbitrators to solve the cases. But number 1 is appointed from the plaintiff. Number 2, arbitrators is appointed by the defendant. And then number 3, sometimes they do not, there is no agreement. So they ask the court to decide. So the court itself make the regulation about that. Must be settled, must be appointed by the court within 40 days. And then 40 days deadline for the district court to rule a challenge against court appointed arbitrator upon receive such challenge from either party. And then 3 days deadline for the court bailiff to register a domestic arbitral award. Just now the from the stage I made there is no deadline, yeah. So it is 3-day deadline. And then 40-day deadline for the foreign arbitral award. And then continue 40-day deadline for the court to issue an exequatur for the enforcement of foreign arbitral award upon application. Sometimes the parties is cheating. They actually they know they must be comply to the arbitral award, but they try to challenge the arbitration award to the court because they don't want to comply to the arbitral award itself. So they are buying time. And then the court in line with the parties because there is no limited time from the regulation number 30. So unlimited time to settle the dispute. So from the new regulation they made it 40 days, 14 days deadline, and then 30 days deadline for the court to rules on the recognition and enforcement of foreign arbitral award upon registration. So only 1 month. So this one is some cases. For instance, Garuda Indonesia versus Virgin Air 2002. Differences between seat of arbitration and venue and domicile of the dependent. So the new PMA do not stipulate it clearly. Repeat only Article 66, 67, Law number 30. So tempat arbitrase itu ada tempat arbitrase dilaksanakan. We said that it is seat of arbitration. Ada yang kita sebut dengan venue of arbitration, venue of arbitration. Misalnya pemeriksaannya di mana tempat defendantnya dan lain sebagainya. Kemudian aturan terbaru, unfortunately, do not stipulated about this. So this is remain becoming a problems for the next year, I think. So Garuda Indonesia versus Virgin Air, and then the next is Persons Enterprise Ltd versus PT Indiratex Pindo Branch Head Indo at London. So actually Indonesia is the member of the New York Convention, but plenty British Virgin do not member of the New York Convention 1958. So if it is registered in Indonesia, it will be enforced because Indonesia is the member of New York Convention. But if it is registered to the British Virgin, British Virgin is not the member of the New York Convention. So you can imagine that it's not easy to enforce the award. And then kasus PLN versus PT Sumsel Energy Gemilang, ini juga they try to challenge, but it is rejected by the Supreme Court. And then London Court of International Arbitration number 10165, the arbitral awards LCIA, PT Daya challenge in the awards in Indonesia, and then it is also rejected in PM Jakarta because the seat of the arbitration is in London, not in Indonesia. And then PT Seaworld Indonesia, PLEA accepted by the Supreme Court, because it is fulfill Article 71. So some cases challenge is accepted, some is rejected by the Prime Court. I tried to browse last night, so it found that 287 data regarding the challenge of the arbitral awards. So I read that some of them are accepted, some of them is rejected, but mostly rejected. Thanks God that our judges and also the National District of Jakarta understand about the arbitration. Okay, so I come to the conclusion that the Supreme Court recently announced a new era for both domestic and international arbitration by enacting Supreme Court Regulation number 3 of 2023 on the procedure for the appointment of arbitration by the court, challenge right, examination enforcement, and arbitral application and arbitral awards annulment. It is hoped that by detailing the change that will reshape Indonesia as the next emerging dispute resolution hub across the continent. So we do not worry that Malaysia also the member of the Convention. So if the arbitration seat is in Malaysia, it can be enforced to also in Indonesia. So that is my presentation today. Thank you very much for your kind attention. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Okay, thank you so much, ma'am, for the solid and informative presentation you gave us. Okay, Now, ladies and gentlemen, now come to the question and answer session. If you have any questions, please raise hand and introduce yourself first. I would like to have two questions from the participants here and maybe one questions from the Zoom participants. Okay? Okay, sir.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Thank you for the mom for the question. I think the presentation, both presentation are very interesting. And from the presentation, we know that recognition and enforcement, especially execution of the arbitration award, is very difficult. First, I would like to ask to the presentation from the Malays. I think I would like to know whether the Malaysian court has the authority to annul or to reject execution of the arbitration award from either from the international of Malays or also from international arbitration award. The first question, and if the Malays court has the authority to reject to execute the arbitration award from either internal or domestic or international, what based on what reasons the authority should be conducted? But for Indonesia, the presentation has said elaborately that many reasons to reject or to annul the execution of the arbitration award. Thank you.
Okay, excuse me, ma'am, Dr. Iliana, can you hear the questions?
Yes, I can hear the question. Can you hear my voice?
Yeah, we can hear your voice well.
Alright, okay. Thank you so much, gentlemen, for the very good question on the annulment of awards. In Malaysia, so the first question is whether Malaysian court has the authority to annul the award that has been made in Malaysia or the contracting states. Regarding annulment of award, we do have we call it application to set aside. This is a basic annulment of the award, i.e. it will entirely annul the award in its entirety. Okay, for under Section 37 of the award, we do govern, but it is only regarding award where the seat is in Malaysia. So for example, if the award is made in Malaysia, the Malaysian court can set aside the award in its entirety. Okay, the grounds for it, okay, which the second question, the reasons where Malaysia can annul the award, there are also 7 grounds, similar to Section 39, i.e. regarding the refusal to annul the award. Malaysia actually adopted this Section 37 is actually from the arbitral model law. The reasons will be the first one, okay, if the party to the arbitration agreement was under any incapacity. The age, or whether they are not in the right minds, for example, The second one, if the arbitration agreement is not valid and under the law of Malaysia. Third one, if the party making the application was not given proper notice and then unable to present their case. The fourth one, the award deals with something outside the scope of the arbitration agreement. And the fifth one, if the award contains decision outside the scope of the arbitral award, arbitration tribunal. Okay, and lastly, if the composition of the arbitration tribunal is not in accordance with the arbitration agreement or the procedure of the that has been set up by both parties. And the other two are also similar to Section 39, which the sixth one would be if the subject matter is incapable of being settled by the law in Malaysia, i.e. Not arbitrable, yeah. And the last one would be if the award is in conflict with the public policy of Malaysia, not international public policy, but public policy of Malaysia. But again, the Malaysian court will only annul the award, okay, if the award was made in Malaysia. But having said so, there were also cases, okay, where the parties, like Dr. Maria says, in Malaysia it happened as well, where the seat was outside Malaysia, but they tried to challenge or set aside the award in Malaysia, but the court has rejected, yeah, and they would only refuse to enforce the award if it falls within the ambit of Section 39 that I've just mentioned in my presentation. But there was certain occasion where the Malaysian court trying to check even more, check the merit of the arbitration proceeding, which is supposedly not within the purview of the Malaysian court, but that happened in the past actually, before we adopted the Arbitral Model Law and also we enacted the new Arbitration Act 2005. Previously, yes. Previously, Malaysian court, there were cases where they tried, the Malaysian judiciary tried to check the merit of the awards. It goes beyond the scope of the Arbitral Model Law, so New York Convention. But the recent decision, no, we only annul awards that was made where the seat is in Malaysia. Does that answer your question? Miss, I'm not sure the name of the name of the one asking the question is not.
Thank you so much, ma'am. The question is from Dr. Bahrul, but he wants to give you another question again, ma'am.
Why not?
Thank you for your good explanation, Ms. Liliana. Actually, I have two questions, but I just delivered one. And the second question is, I would like to know how about if the arbitration execution is upon the government's upon the or state assets. You know that now there is a arbitration award against Indonesian governments that should be executed upon Indonesian embassy building in Paris. And what about it is in Malaysia? Thank you.
Thank you so much for the question. Okay. Yes, actually, regarding state assets and enforcement against countries or states, yeah, it is governed under ICSID, International Convention on this investment disputes. Yeah, usually relate to investment, right, between the investor and also the states or state entities. We do have it in Indonesia as well, and so far I'm not sure whether Indonesia is also a party to the ICSID. Perhaps Dr. Maria can help me with that. Yeah, but for Malaysia we are party to ICSID convention as well, and we do enforce ICSID if let's say the conditions has been fulfilled. Yeah. But against the Sulu, yeah, Malaysian government against the Sulu Act that is still ongoing right now in the court in Paris, where the Sulu Acts are now trying to also aim for our Malaysian assets to enforce the awards given by Dr. Champa against Malaysia. We also face the same issue, but what we can changing the enforcement of that award. So perhaps that's what the Indonesian government has been doing as well, and what they should be continue to do so, because the nature of the award is the convention allows it, yeah, to be enforced everywhere in other contracting states. Okay, if it has been annulled in this in where the award was made, then we can safely say that the award has been annulled. Having said so, there are still certain countries, okay, that accept a non-award to be enforced. So perhaps, for example, the case against Malaysia, if the other party would like to enforce the award in Malaysia, of course the Malaysian court will not allow it because we have been consistently against the award. But now, if they would like to enforce the awards against Malaysian government, but in other contracting states of the convention, that will become a problem because then Malaysia will need to challenge those enforcement and recognition in each and every state to make sure that our sites will be protected. I believe that will be the same in Indonesia. Is that okay, Doctor?
Dr. Liliana, actually, Dr. Bahrul is the practitioner and also lawyer that sometimes commencing the proceeding, the arbitrations cases, yeah, in Bani and also in other countries, yeah. He's very popular actually. The question is just because he just want to talk to you, I guess, yeah. Okay. Actually, Indonesia.
I'm so honored.
Yeah. Actually, Indonesia also is a member of International Center for the Settlement of Investment Dispute. Yeah, so the country ratified the Washington Convention 1968 through the law number 5, which allow ICSID to handle investment dispute between Indonesia and foreign investors. So it is because Indonesia would like to attract many investments. So Indonesia ratified the ICSID Convention. Therefore, after the ratifications, Indonesia can settle some cases regarding the investment dispute between Indonesia and other foreign investors. So it is allowed, yeah, it is allowed. So Indonesia also has been involved in several ICSID cases since 1981.
Okay, thank you so much, ma'am, Dr. Iyana and Ma'am Mary for the answers. And maybe any other question from Zoom participant? Any questions from the Zoom participants, maybe? Okay, maybe from the audience here, any other questions to Ma'am Mary or Ma'am Dr. Iliana? Any other questions? While we wait for questions from Zoom participants. Oh, okay.
Okay, thank you, Miss. My name is Putri. I'm from international law student. So my question is, in the context of public policy as a ground for revising enforcement, how do Malaysia and Indonesia interpret and apply the concept of international public policy versus domestic public policy? And what impact does this have on cross-border enforcement predictability? And also the next question is, should ASEAN countries work toward harmonizing their standards for the recognition and enforcement of international arbitral award? Thank you.
Dr. Liliana or me first?
It's better that Dr. Mary can start first.
Okay. Okay. First, we give time for Ma'am Mary to give the answer first, then Dr. Iliana.
Okay, what's your name? Salsa. Okay, very good question, Salsa. Yeah, Salsa. Actually, I said just now that Indonesia has a new regulations from the Prime Court number 3, 2023. They try to actually, indeed, from the regulation number 3 of 1999, also regulation number 181, there is no specific regulation that give the definition regarding the public policy. Actually, I said just now that from the under the Prime Court number 3 of 2003 means that everything that constitute the very foundation essential for the functioning of the legal system and an economic system and social culture system in Indonesia community and nation. Actually, it is really wide, yeah, wide, and it can be interpreted in many ways. But if it is break the ground rules of some principle in Indonesia, for instance, there is a piracy over there is a homicide over there, and then a fraudulence over there, or it is against really the public interest, means that the parties can challenge the arbitral award, yeah, the arbitral award. And then do you think that the second question is about? Actually, this is very difficult, but some of Asian countries are also the members of the New York Convention 1988. So I think it's quite the same that if it is arbitration, international arbitral awards must be imposed to Indonesia. So of course they have to follow the rules of in Indonesian country. If it is what we call it, must be enforced to Malaysia, means they must be follow the rules in Malaysia. Yeah, it could be harmonized, but if really the same, I think is very difficult. Yeah.
Okay, thank you so much, ma'am. Next, our speakers, Dr. Iliana, you may answer the questions.
Okay, thank you so much for the question, Dr. Amelia. Alright. Okay, regarding the concept of public policy, okay, in Malaysia, the Malaysian courts has ratified in various cases. They are trying to define, because law is all about definition, right? How we define things. Public policy has not been defined in the legislation. This is similar to Indonesia, but in cases, the Federal Court of Malaysia highlighted that public policy must be stipulated, must be defined as narrow as possible. If the award must not offend Malaysia's most basic notions of justice, fairness and morality, and must be recognized internationally, not just merely based on the domestic standards. That has been what been said in the case of Ajwa and food industries, Jangling Bill, cement industries, and the recent one in the TMF Trust Labuan. It violates the international public policy if it is very serious, substantial and material to international public policy. Other than that, usually it will not trigger the public policy exception under Section 39 of the Malaysian Arbitration Act. And whether it would impact to the investment. So because the court has been trying to define it very narrowly, we believe that will not have direct impact to the investment position or attractability of Indonesia. And I also share similar opinion with the Honorable Dr. Murga relating to whether we should go for a proper, uniform or harmonized guideline on REFA or Regulation Enforcement. Countries in Malaysia, they have, even in Malaysia and Indonesia, we have our different standards, not say standard, different way of interpreting, different historical backgrounds of law. Perhaps we should hope for convergence, i.e. Similarity but not total harmonization or uniformity, because it's very hard. But when it is very interesting presentation from Dr. Miria. Now I know that now Indonesia have the new guidelines and new regulation just in 2023, I believe. when I look at that, the way Indonesia is now progressing and is transforming is not similar to our in position in Malaysia. So we can see that now, in terms of recognition and enforcement of foreign awards, Malaysia and Indonesia are converging, almost coming to similar, but not total similarity. Yeah, that's all.
Okay, thank you so much, ma'am, for your insightful answer to the questions. Okay, now, so we finished this international public lecture with 2 questions from the audience. So, ladies and gentlemen, we finally come to the end of this international public lecture. Before I close this class, I'd like to take the conclusion where the recognition and enforcement are crucial elements of the arbitration. Without the possibility for the winning party to enforce the arbitral awards in its desired country, the whole arbitration process becomes pointless. So, the comparative study are needed to provide a clarification to the arbitral award in Indonesia and Malaysia. So, okay, on behalf of organizing committee, I sincerely thanks Dr. Iliana binti Cerosli for your time, and Dr. Maria Utama S.I.L.E.M. to be here with us for sharing their expertise, and I also thank all the participants for engagement. I hope to see you again in the future discussion. So, I am Riza Qadiata for today's public lecture. Say goodbye and have a good day. Wassalamualaikum warahmatullahi wabarakatuh. Thank you so much, ma'am, Dr. Iliana and Dr. Mary.
Thank you so much, Ms. Riza and also Dr. Mary. Thank you so much for inviting me. See you again, inshallah.
Thank you.
Assalamualaikum.
Okay, we extend our sincere thanks to our speakers, Dr. Iliana binti Cerosli and Dr. Maria Utama S.H.L.M. And we also want to thank to Ms. Riza Claudia Putri, SMH, for moderating the discussion. My knowledge shall be beneficial to all of us.
We have now arrived at the conclusion of today's event.
International Public Lecture with the theme Recognition and Enforcement of International Arbitration Awards, a comparative perspective from Malaysia and Indonesia, initiated and organized by the Faculty of Law Universitas Sriwijaya as part of the Sriwijaya International. So let us close this afternoon's event by reciting a hamdalah together. Alhamdulillahirabbil alamin. I am Surasa Putra and my partner
Alia Deska Safira.
as Master of Ceremony.
We would like to thank you for your participation. May this event bring benefit to us all.
Lastly, wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Oke, saya mau ngucapin terima kasih kepada para mahasiswa yang sudah dengan baik ada di sini. Sebentar ada pengumuman dari Pak Muslim. Oh iya, makasih banyak ya.